Frederick Mpanga, Tugume Moses, Katotu Musime, he has stepped out. And on our side, for A1 and A2, there will be a few questions from Tugume Moses, then I'll conclude. Both of us will take very little time. And then for A3, I'm informed that Nsubuga Simon will also be asking some questions. Then we'll have we'll begin, and I will.
Maybe, my lord.
About 30 minutes to consult among ourselves before we pronounce Birivumbuka's application has come as ambush. Although we were with him in court for 30 minutes, more than 30 minutes before you came in, he didn't mention. So we have had no time to consult, and we have realized we need slightly longer time to consult. So we are asking the court to give us 30 minutes so that we do not inconvenience the court continuing with the consultations.
Senior counsel whether they withdraw the application
on our responses. Yeah, and we request that the accused persons stay in court so that we also involve them in our consultations.
Council must you have asked for time to discuss
and among ourselves,
which I have already done.
Yeah.
Now, to one further discussion. My question is to respond whether
I think there are some things that are clear to us, but it is important, especially where there is more than one advocate, that we be reading from the same script so that we are also precise and we don't take too much of the court's time. In any application, there will be remarks that will have a bearing on the ultimate decision of the court.
Maybe it's unfortunate. He said there is no law, have this application withdrawn or not. Maybe there is any other law, you can just
that we will be coming with that. And we can assure the court that we will not take too much time. We'll consult and then have our arguments properly packaged. Our remarks. Objection to the withdrawal of the application, but we are urging that the court allows the withdrawal with prejudice. Mr. Birivumbuka's I've just asked the court, said we have no objection to the withdrawal, but they feel with prejudice that you cannot bring the same application again, especially so because the prosecution has waited for the court to utilize 2 days of cross-examination of the witness, yet nothing new has happened, they could have evaluated the options open long before they brought the application. We therefore believe that the application has been made at this stage because the prosecution has realized through the cross-examination that their application was ill-advised and has no grounds to stand on. We are therefore asking, my Lord, that the court takes the unusual step, utilizing its inherent powers to allow the withdrawal on a prejudice basis, but to also take the unusual step to award the defense costs of the 2 days this application was prosecuted, which cost should include my airfare from Kenya and back for 2 days. Because it is unnecessary that for any of us to bring an application where you have other alternatives. We also do seek the courts to require the prosecution to obey its earlier order on full disclosure and to give a timeline so that we may return to court for scheduling and for the court to be satisfied that the full disclosure has been made and therefore the case is now ready to proceed. Before I proceed to my colleagues who may want to make additional comments, I want to draw the court's attention that we do have a bail application. I don't know whether the court wants me to do this after that, this application. We do have a bail application, criminal application number 0213 of 2026, which has been allocated to you, my Lord, and we'll be seeking for dates at the end of this, noting that our clients have been in custody, A1 and the A2 have been in custody for a whopping 558 days as of today. I don't know whether Apollo has something. Then that's all. For A3, that's all for A1 and 2. For A3, disclosures have been made, and upon the disclosures being made,
I say I have made the report, it's a must.
then the defense, then
Tomorrow, I have made the report.
is in the next step the scheduling of the case, a date for that to happen, in which case after the disclosures we will have assessed the time we need for preparation. In the absence of disclosures, we would not be able to know. Yeah. Assuming that the accused persons have no right to prepare their defense.
What I'm asking you
No,
now. For him, he said that he confirms that you will follow the order of court.
Yeah.
You will follow disclosure tomorrow.
Okay.
And she's applying for the hearing date. So
Okay, then I'll let my colleague Mpanga respond to that. Information on assessors is insufficient.
what is this?
We need, if it is one has a degree where they studied, we need a short bio. Yeah.
What is this?
If you look at that,
Let us get to start with one with
they are all the same.
what is this?
It is indicated they have, like in this first one, it's indicated she has a degree in accounting and finance.
My question is, what is missing that we can provide?
The university she went to. You know the way one
which
is.
law requires the assessor to have the university degree?
But how are we able to do it's not, I am not saying that the qualification, there is a law requiring. It is the information given. If you say you are O-level, if you say you are O-level, we expect you to say, and I went to this school. Then a background check can be done. We expect to know where they come from.
My question is,
Yeah.
maybe you guys vote on
Applications for appearances of fairness.
I am saying, is that you don't need the matter is I mean,
No, it's been allocated to you.
The prosecution rose to ask the court to be allowed to withdraw the application. We couldn't oppose the withdrawal because our position from the beginning is that the application had no merit and it was going against the right to fair trial. You cannot be subjected to trial with a blindfold where you do not know who is your accuser, where the evidence is coming from. So whereas we welcome the withdrawal, we also note that the court's time has been wasted, and we said it to the court because 2 days of cross-examination, the prosecution must have known that their case was very weak, and that is why they have withdrawn to avoid dismissal. We asked the court to allow withdrawal with prejudice, meaning they cannot bring such an application again. But the court has given them a free hand. We also asked for costs. The court also has not allowed the costs. And the court now has ordered them to give full disclosure by tomorrow and ordered us to come back to court on the 1st, which is Monday. We are not happy with that because we will not have had time to sit down with our clients to know what is contained in the full disclosure, to get instructions, and for us also to be able to advise our clients. When we express displeasure in court, especially of the judge refusing to give us a date for our bail application, yet he is giving prosecution dates on every application they bring, including the one that he has just finalized. He has requested us to go and canvass that in chambers with the prosecution. So from here we will go to chambers. But we and our clients feel that the judge has not treated our applications fairly. He's giving the prosecution priority. The scales of justice must always balance between the defense and the prosecution. And a court of law should never be seen to be leaning on one side. We have at least pointed that out to the court.
No question.
Fu Said, an observer, he has been here before, all the way from Senegal. He's a Comorian practicing law in both Paris and Senegal. And he has come here to see how things are going. So we are glad that the outside world is also, through the lens of the media and the lens of observers, able to follow what is happening. And don't forget, today is 558 days since Besigye and Lutale were abducted from Kenya.